Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Team, today we're going to talk about an application brought by an employer in respect of what we sometimes refer to as a restraint of trade. Today's case is about a management consultant, and in about 2022, this management consultant moved from one very large sort of consulting firm into another very, very large consulting firm. Later in 2023, the management consultant moved to another consulting firm related to the 2022 one. But I just want to tell you a couple of terms of their employment in relation to what happened there. So when the management consultant moved to the 2022 firm, if we'll describe it that way, they accepted a 2-year restraint on what they were allowed to do at the conclusion of their time with the 2022 employer. They said, for 2 years, I won't touch that employer's clients, that sort of thing. Signed up to that agreement. Now in 2023, the new 2022 employer went through a reasonably significant scandal. There was a restructure, and what happened is that some of the 2022 employer's work, particularly done for government clients, was sectioned off into a different entity or different set of entities. And what happened is the management consultant we're discussing today signed up to be employed by that new entity that was then handling the 2022 employer's former government work. Does that make sense? Doing government work in the defence space, moves from the 2022 employer to a new entity that was founded following a restructure. Now, as part of signing up with that new entity, our management consultant accepts a 1-year restraint and accepts a term of leave that is 3 months in relation to gardening leave. And in essence, the nature of that term is that the employer can say, the moment the management consultant quits, the employer can say, bing, you're on gardening leave, you're not allowed to do or touch anything or speak to any clients or do anything, the name, so just go to the garden at your house and do a bit of gardening for the balance of your employment period, of that notice period. So the management consultant signs up to that. That happens in early sort of November 2023. Later in November 2023, the management consultant comes to the new employer post the restructure and says, hey look, I'm going to take a role at a different consulting firm, and so this is my notice period. I'm going to be leaving the employee of the newly restructured firm. Does that make sense? I hope it does so far. So giving the notice, they're quitting, right? What happens then is that the employer, who is the plaintiff in today's discussion, sends a letter to the management consultant that says, great, we've got your notice that you're going to quit. The 3-month gardening leave starts now, so do nothing for 3 months. And we're going to hold you to this 1-year restraint that, remember, you signed up to the employment agreement, we're going to hold you to this restraint. Now, reasonably promptly, the management consultant replied to say, check, yep, got it regarding gardening leave, but in relation to the restraint, no, I think the restraints are unreasonable, so I don't consider I'm bound by those. Off goes the letter. So our management consultant, who is now on gardening leave and may well be near their garden, hopefully, enjoying some deserved rest and this sort of thing, but occasionally sending emails, is through this time going back and forth with the former employer. Some of that back and forth is the former employer attempting to entice the management consultant back to work, and part of the back and forth is between the lawyers for the management consultant and the lawyers for the former employer. Now, the management consultant lawyers essentially say, hey look, the restraint, we say our client is not bound by it, and if you want to serve originating process, if you want to kick off some court proceedings, you can serve it on us, and that's fine, and we're ready to have a dispute about it, we're ready to litigate it. Now, that doesn't end up happening through the gardening leave, and the gardening leave comes to the end at the very end of February 2024, and it is only on that date that the plaintiff, the former employer, launches a court application to try to hold the management consultant to their restraints. Put another way, to try to stop the management consultant from going off to work at the new consultancy that they'd said they were planning to work at. Now, that is the application that we are dealing with today. We are dealing with the employer, the plaintiff, attempting to restrain the management consultant from going off to work with this new consultancy firm that operates in a sort of similar sort of space, doing government work, defence work, that sort of thing. Now, in order for a restraint of this kind to be enforceable, it must be to protect the legitimate commercial interests of the employer who's seeking to enforce it. And so the court, noting this as an interlocutory injunction application, it's an application for an order that takes effect right now, the court has to consider whether there's a prima facie case that the restraints in this contract do indeed protect, I was going to say prevent for some reason, protect the legitimate commercial interest of the employer. And the court has a look and says, well, on this prima facie basis, this interlocutory phase, it looks like, yeah, there are some commercial interests that ought to be protected in relation to confidential information. And there's some evidence here that shows the management consultant previously signed up to a 2-year restraint. So a 1-year restraint may well be necessary. It looks like in this kind of work, it is at least arguable, there's at least a prima facie case to say, yeah, these restraints are indeed reasonable. So when we're thinking about an interlocutory injunction, you've got to say you've got a prima facie case, and you've got to say the balance of convenience favours the injunction. So on that prima facie case, the employer has succeeded. You know, the employer's been able to say, hey, look, there's a strong argument or a reasonable argument that these restraints are enforceable and they do bind the management consultant. The next question is the balance of convenience question, right? And that question is sometimes framed on the basis of, hey, is the injunction, is stopping this behaviour so important that it can't be cured just by requiring someone to pay some money to someone else? Are damages an appropriate remedy? And so here in this argument we have the management consultant not putting on a lot of evidence about their financial position and not really raising an argument that might be something like, oh, if I was prevented from working for this new consultancy, I'd go bankrupt and I wouldn't be able to afford the school fees and these sorts of things. Instead, there's not a lot of evidence on, or there's not profound evidence on in relation to the management consultant's financial position. There's some evidence that they have a tax debt that arose from having a significant income in the past. There's some evidence about expenses, but it's slightly imprecise. And an inference pursuant to Jones and Dunkel, a decision of the past, arises that the management consultant had access to evidence that might have been able to prove her financial position, but chose not to put that evidence forward. And so an inference arises that that evidence would not have assisted them in resisting the application. And so it looks like the management consultant is going to have real difficulty arguing that the balance of convenience favours not granting the injunction. It looks like there'll be a strong argument to say just grant the injunction because the management consultant is wealthy enough that they'll be able to deal with not having work until there's the final hearing of this matter. So it looks fairly good for the employer at this stage because they've proved the prima facie case and it looks like they're doing well on the balance of convenience argument. But, and this is a crucial and pivotal point, there was delay. Do you remember back in November 2023, the employer said, oh, we're going to enforce these restraints and we consider this very solemn. And the management consultant said, no, I don't accept it, they're reasonable. While there was some back and forth over the months that followed, this litigation, this application for the injunction was only sought right at the moment the management consultant was about to commence work with the new employer. And the court said, look, this significant delay isn't adequately explained by the evidence, and delay can be a complete answer to an interlocutory application. It can be a complete, I'll use the word defence quite loosely. And in this case, what the court said was essentially that the plaintiff had belatedly realised this was all urgent and had not explained their delay, and so the plaintiff failed in their attempt to have the application restraining the management consultant granted, and so the management consultant was free to go ahead and work with a new consultancy firm. I hope that discussion assisted you, and I look forward to chatting again soon over another coffee and in respect of another case note. Cheers.